Welcome to Litigation Capital.
Hello, everyone, and welcome back to Litigation Capital with Steven Mirsky. Steven's the founder of Mirsky Corporate Advisors, and in each episode, he breaks down high-stakes legal issues affecting companies like yours, those earning $10 to $100 million a year, so you can turn complexity into leverage and protect what you've worked so hard to build. I'm Sean O'Connor, and today, Steve and I are talking about choice of law clauses. Steve will go over why courts sometimes disregard the law the parties selected and how that decision reshapes the entire dispute. Steven, good to see you.
Nice to see you, Sean.
So let's get right into it. When a contract names a specific state's law, what threshold issues do courts examine when applying that choice of law provision?
So it's a very high standard to overcome that, right? The courts recognize that the parties have the freedom to contract, and they assume that the parties entered into a contract freely and volitionally. And so in California, the standard is that you need to show that the application of the foreign law would, among other things, be contrary to a fundamental policy of the state with a materially greater interest in the transaction. So the first question is, what is a fundamental policy?
Right.
And the second one is, what's a materially greater interest? And so you have to tie in whatever the core issue of the dispute is to the policy of the two states. And then you have to make a factual argument about materially greater interest. So it's a very high burden, especially at the onset of litigation. And so it's one that needs to be undertaken only if there is a very material impact on the litigation. Like, let's say I have a breach of contract case and the contract law is in California or New York. Well, it's kind of a mundane issue. I'm not going to go all in on a choice of law issue for just that simple issue. But if there's something that's very particular that can make or break your case, such as usury, then I'm going to have to go all in, and this is the mechanism that I'm going to use.
Well, so how does a judge determine, whether enforcing the chosen law would violate the fundamental public policy of the state?
As part of this test, there's a couple of things that we have to do, and the formal name for the test is Section 187 of the Restatement Second of Conflicts of Laws. And in that, just very simple stuff.
That one.
Right? Yeah, and it's a three-part test, four-part test, I would argue. So first is you have to say, is there a substantial relationship to the parties of the transaction, or is there some other reasonable choice? If the answer is yes, then you have to ask whether or not it violates a fundamental policy. And only if that answer is yes, then you ask whether or not the state that has a materially greater interest in the transaction outweighs that decision. So the court will then need to look at what is a fundamental policy. And so it's going to look at public policy provisions that have clear and unwaivable rights. The other thing that the court is going to look at is, well, are there factors as to why the other party chose the other law? Like, we're assuming in this case that we don't want California law. Is there a reason why they chose New York law or Delaware law or something else? And a court's going to look at, well, are there weaker regulatory protections? Is there the ability to waive a remedy? And those are the factors that the courts are going to look at to determine whether or not someone has a materially greater interest. And I think also they're going to look at the public policy underlying the protections that the parties are arguing over. What did the legislature intend when it enacted these laws? Are these laws embedded in our Constitution, the state Constitution? These are factors that will determine whether or not something is fundamental and whether or not there's gamesmanship by the other side to circumvent reach of those laws.
Yeah. So, in cases or matters that you've handled, what indicators suggest that the selected law was chosen to avoid scrutiny, rather than to govern the transaction on its merits? You're kind of hinting at that a little bit.
There's a number of factors, but I tend to look at behavior of the counterparty. So let's get outside of the law or the contract just a little bit, and let's look at how the parties are interacting with each other. California law requires lenders to register with the state regulatory agency. Have these parties done that? most or all states, if you're transacting business as an entity, require you to register as an entity. Has the counterparty done that? What is the style of the communication that's coming from the other side? Is it professional? Is it firm? Is it more gangster-like, right? Like, I'm coming after your children type of discussions. These factors, when you like, oh, they're not registered to do business, they're not registered with an entity, and they're talking like a gangster, more likely than not, they're using the law to circumvent some statute, right? These are not sophisticated parties. If there is some sort of indicia that the party is sophisticated and there's a legitimate business purpose behind this, it's going to be a little bit harder.
So how do courts evaluate the relationship or lack of one, between the chosen state and the parties when deciding whether the provision is enforceable?
Well, again, you're going to look at the relationship of the chosen state and the parties. It's the first part of the analysis. And some of the factors that the court will look at is where the parties are domiciled, right? Case in point, had a case the other day where the contract stated that it was between a Florida entity and a California entity, and that all litigation would commence in Florida, right? That's the premise of the statute. Well, they sued in New York without a New York entity and without any sort of connection to New York. So we were able to kick that case out because they're like, why are we in New York? There's nothing in the contract. There's nothing else that's connecting the parties to New York. Why are we here?
Why were you there? Why? What?
Because these guys are dumb and lazy. That's the simplest answer.
Oh yeah.
You have these litigation mills that just send stuff out on a template and then facts be damned, right? So that's what happened in this case.
When the economic structure of the deal contradicts how the chosen state classifies, say, loans, sales, or usury, how does the mismatch influence the court's analysis?
I don't know if the mismatch itself influences the court's analysis. I think it goes to the circumstances that we're negotiating. Case in point, I have a case right now where a guy was given $1 and in exchange had to pay back $1.9 million in 60 days. And so I think when you have a certain...
Wait. Run that by me again.
$1 in exchange for 1.9 in 60 days.
Okay.
But that's not a loan, right? And so, a court's going to look at those types of factors and say, all right, what's the real premise behind this transaction? There's no way in a jury or most people with just common sense will look at this and go, oh yeah, no, that's not a loan, right? It just smells fishy. And so I think those types of, that's not a very legal argument, but it's a very common sense based argument where, if something doesn't look right, it doesn't smell right, and it unfairly impacts one party that the court has jurisdiction over, a court is more likely than not going to want to keep that in its state.
Yeah.
And I'll preface that, I'll put an asterisk around that with a state court is more likely going to want to keep it. Federal courts behave a little bit differently. Federal courts are courts of limited jurisdiction. So if they can find a reason to kick it out of federal court, they're going to do it. State courts, at least in my experience, tend to be a little bit grabby and they want to retain jurisdiction.
How do judges construe choice of law clauses when they sit alongside forum selection provisions that, point to a different jurisdiction?
Most judges are just going to apply what the contract says. I mean, they don't really want to get into an analysis. Some judges just don't care. Their dockets are huge, so I understand. Some judges, though, in my experience, really like the academic exercise. It's an engaging issue. It for me, as a practitioner, it kind of feels like law school sometimes where you're presenting, something that the court doesn't see every day. And you're walking them through the analysis and the issues. And some judges really enjoy that intellectual exercise. Others, though, say, the contract says this, we're doing this.
Yeah. It's interesting, right? Like it comes so much of, not so much of it, but oftentimes in conversations like we're having, there's the law, there's the statute, there's the rules and regulations. And then there's just the people involved. And, you get some judge who's like, hey, I wouldn't mind having a conversation about this today. Let's dig into it.
Yeah.
And another judge is like, get this the hell out of my court. I got 17 more cases to hear.
I've been on all ends of that spectrum, and that's why you have to tell clients, like, look, the law may be on your side, but there's another party involved, and that's the judge. And my job is to convince the judge. At the end of the day, the judge makes the decision, not me.
So in disputes involving aggressive financing arrangements, how do the parties conduct before and after execution affect which state's law ultimately governs?
There is no choice. The choice is you sign this damn contract the way it is, or you don't get the money. And there's a reasonable approach to that, right? As a lender, I'm not going to make every contract be different for somebody else. Plus, I want to stack the deck, right? My job is to make sure I get my money back.
Yeah.
As a borrower, I find that most of the debtors I represent in these types of cases, they don't really have the sophistication to even lawyer up on the prior to execution, right? And usually these people aren't even talking to the end user at the lender themselves. They're talking to a broker, and the broker's kind of facilitating a deal through. And so everyone's saying, just sign, because broker wants commission and debtor wants money. If we're talking about a more sophisticated transaction with enterprise level companies, for what I would call like legitimate financing, so some sort of construction loan or revolving line of credit or a commercial lease, things will be negotiated. And again, the lender's not going to want to move too far off of its template because it's got a whole portfolio of business that it wants to execute, and it needs to have consistency. But if, for instance, a company has a very compelling interest to keep it in, state X, I have found it in my experience on the lender side to have been like, all right, whatever, we'll use that.
How do courts treat situations where applying the chosen law would convert an otherwise unlawful transaction into a lawful one?
So that's it's an interesting point. There is a presumption, especially as it relates to usury, there's a presumption against finding a contract to be illegal, right? Because the part, and we have severability clauses that say, hey, look, to the extent any provision is unenforceable, let's modify it so that's enforceable. That's where you need to have a broader look at the transaction and what's going on. For instance, in that $1 for $1.9 million, it's going to be extremely hard to find a way to prove that transaction is a lawful transaction. It doesn't make sense to me from a common sense perspective. And I think when you have those kinds of disconnects, a court's going to look into it with more scrutiny. And so, I think a court is going to be extremely selective about overriding a choice of law provisions or finding a contract's unlawful. The facts need to be very compelling, both within the contract and outside of the contract.
You were talking about the larger enterprises and that sort of thing. I'm curious when, for CEOs reviewing agreements, which clause patterns tend to signal that a choice of law provision may not survive judicial scrutiny once litigation begins? Are there, I guess, red flags or things that you need to be looking out for?
To be frank, the governing law choice of law provision on the front end of any business deal, in my experience, is a throwaway clause. What do I mean by that? Most attorneys aren't going to look at it, right? When you're in-house, 9 times out of 10, you're saying, hey, look, if there's a dispute, we're going to negotiate out of this, right? So this is just, protection for, our assignees or whoever else we're going to work with. And so it becomes important on the outside of litigation. And so I guess one of the things I would look at is this counterparty litigious, right? What's their outside of this contract, what's their behavior? And what are some indicators that give rise to their temperament? And so clauses that I would look to are strangely worded arbitration law clauses, clauses waiving service for one side but not the other, just certain mechanisms that are in place that give the other side a procedural advantage when and if litigation ensues. And from there, I would infer that the choice of law clause is there to kind of lock in whatever procedural mechanisms they've already outlined in the contract. So to answer your question in a more direct way, we want to look at the character of the counterparty, have counsel do a search, see if there's a lot of litigation with these guys. If not, take a look at, or if so, take a look at the contract itself, determine if there's, and your counsel determine if there's mechanisms at play that give the other side a procedural advantage, a significant procedural advantage. And if so, then I'd say, hey, this is a contract we need to look at more closely. And then also look at the name of the party. I mean, I can't name names, but if someone's named after a vegetable and they're lending you money, you may want to look at that a little bit more closely.
Well, let's make that the headline. If they're named after a vegetable, beware.
Yeah.
Always, yeah. Take that. That applies to almost every aspect of life,
except for VeggieTales, apparently.
Yeah. There you go. Well, that's super interesting, Steve. We're pushing up against time. It's great to see you, and I know we'll talk more in the near future. You have a great day.
You too. Thanks, Sean.
That's it for today's episode of Litigation and Capital with Steven Mirsky. To learn more about Steven and his work at Mirsky Corporate Advisors, visit the website mirskycorporateadvisors.com. I'm Sean O'Connor. Thanks for listening, and don't forget, like this episode, subscribe to the podcast, or leave a review if you found this episode or others helpful. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.